Take all the memos.
Page number judgment, page number 1 to 4. Page number 5 to 6. Page number 7 to 10. Page number 4, serial number 11 to 13. Page number 5, serial number 14 to 17.
Serial number 17. The earlier advocate petitioner advocate in NOC, today I was issued the wakalat 2 days after.
Learn counsel so and so. Take his name, write your name. Submits that he has received he has received a notice of wakalat. He'll be filing. Let's this matter on 27th.
Lords, serial number 16.1, Lords. I undertake to file wakalat.
Mr. Gauri Shankar.
Yes.
Mr. Gauri Shankar submits that he has instructions to file wakalat. Let's just both the matters on 27th.
Please.
Yes.
Page number 6, serial number 18 to 23. Page number 7, serial number 24 to 32.
30?
30.
Huh.
Time will be granted to comply with officer.
For complying the office objections, a week's time is granted with the default clause. Yes. Yes.
Page number 8, serial number 33 to 40. Page number 9, serial number 41 to 47.
Serial number 44, my lords.
Yes.
Week's accommodation, my lords. 40, because now recently we have appeared, my lords.
Because it's senior counsel for office objections, I have accommodated. Let it come. All are for that only. Everybody is waiting for that. Yes.
Page number 10, serial number 48 to 52.
My lord, serial number 50, my lords. May I see tomorrow, my lords? Some inconvenience today.
At the request of learned counsel for the petitioner, not tomorrow. Tomorrow is tomorrow.
Please, my lord.
Page number 11, serial number 53 to 58. Page number 12, serial number 59 to 65. Page number 13, serial number 66 to 69.
Serial number 59, my lord. A week's time may be given, my lord. Final argument, I am preparing synopsis.
Miss this matter finally on 28th. No further adjournments.
Serial number 70, my lord. Next matter, my lord.
Yes.
Serial number 70, my lord.
Yes.
Both counsel on record are on VC, my lord. Myself and Mr. SB Sheikh. May I seek 2 days accommodation, my lord? Any date next week, my lord?
20th.
In the first matter, my lord. 70.1, I am there as a petitioner.
Both the counsels discuss matter on
20th, Lordship, if it is not going to be inconvenient. 20th.
20th.
Okay.
Yes.
My lord, please oblige, my lord. Oblige.
20th.
Please, 20.
Oblige. Much oblige, your lord.
Please.
Which one? 60. 66. At the request of Lankan for the respondent, at the request of Lankan, this matter on 25th.
Page number 40, serial number 71 to 73. Page number 15, serial number 74 to 78.
Number 74, your lords. 1 week time.
74.
Final day.
And next part.
Why?
Citation, 1 week time.
Below the board.
Have you informed the other side?
No, I will inform.
This is matter on 21st. Yes. At the request of Lankan for the petition. Yes.
Page number 16, serial number 79.
But serial number 79, 21st it may be.
Inform the other side.
I will inform.
What I request advocates is please inform and make a mention.
I will inform. On 21st it may be.
Repeatedly I have to say this. On 20?
First.
The request of counsel petition is this matter on 21st.
Yes.
Is called the list.
Order by still number 1. Are we taking the
As this matter.
Status matter. My lord, in this case, my lord, in para number 8 of the my lord, the judgment, whatever the mentioned, my lord, that has been same has been our taken in the my lord, affidavit.
Let's see that. No, at least you agree that when section 471 contemplates 6 months,
6 months.
then you have to say in your plaint, like when the cause of action arose, when are you filing? Whether section 5 applicable to this for filing instituting a suit?
No, my lord.
Then
That is not
the suit is
applicable.
barred by limitation.
Therefore, my lord, the trial court has my lord liberally taken them.
How can it take when there is nothing? It is beyond the powers. How can when there is no provision for section 5 for instituting a suit? Then where is the question of giving a liberal and a liberal interpretation granting you the relief?
Because my lord, the sufficient reason has been shown by the
Please understand. Sufficient reason will come to play when there is a section 5 if the limitation act applies. For instituting a suit, there is no section 5 limitation. In that case, question of considering it will not arise.
Yes.
Their appeal has to go, your suit will go. Their petition has to be allowed.
My lord, I feel my lord, it is in a liberal my lord,
There can't be a
because my lord,
liberal.
Supreme Court in
It is condemnation of delay liberal. Where is the condemnation for instituting a suit? Where is condemnation of delay?
suit is there is no limitation. My lord.
And then question of liberal construction will not arise. As you said, pending proceedings, that also we are not looking at. We are looking at when did you institute the suit? And was your suit within limitation or not? That is precisely the case.
Within a 6 months, has to file the.
Within 6 months you have to file.
Yes.
And even if you are filing it after the 6 months also, there is no limitation for that. I mean, you can't file an application for 5.
Along with my lord, the application, my lord, I filed the petition before the district court, my lord. In the district court before, my lord, in affidavit, my lord, I clearly stated that, my lord, I have approached a wrong forum and because of family inconvenience, my lord, I could not.
Again, you're going back to the same. That the wrong forum you approached after 12 years. Even by that also, even assuming that section 5 is maintainable, let's say that section 5 is maintainable. Even then also, after 12 years, you approach a wrong forum. Then who will your limitation once starts running? It starts. It won't stop. If it stopped at 2014, from 2000 to 2014, who will answer? It has to go.
Yes.
Please come. Agreed by the orders passed in miscellaneous 177 of 2018, dated 2nd November 2018. The you're for the corporation, respondent corporation, the respondent.
I'm for the petitioner no. Yeah.
That I understand. You're for the corporation. The respondent, the respondent defendant corporation is before this court. The respondent herein, who is the plaintiff, had filed OS number
891 of 2014.
had filed OS number 891 of 2014, seeking recovery of an amount of rupees
3 lakh.
3 lakh.
3,13,592.
3,30,590. The suit came to be decreed by judgment and decree dated 29/7. What is this 2 days? If you look at page 44, judgment and decree 2 dates it is reflected. Page 44.
29/7 is correct, my lord.
29/7/2015. Agreed thereby, the corporation has filed RA number 1 of 2016 that by order dated 23rd November 2016, the appellate court had set aside the judgment and decree dated 29/7/2015 and returned the plaintiff and directed to return the plaintiff to the plaintiff to present the same before the competent court, as he has filed the suit on the file of the first additional civil judge at Belgavi, but as for section 471 of the Karnataka Municipal Corporation Act 1976, a suit lies to the district court. Thereafter, petitioner had the plaintiff had filed Where is that? After that, what did you file? After this regular appeal,
Yes.
where is the suit? What is the suit number?
No, my lord, at annexure, yeah, PM, my lord. Miscellaneous appeal, 177.
Miscellaneous appeal. Oh.
Page number 13.
Page number
13.
13.
13, my lord. Annexure A.
After that, yes, file miscellaneous 177 of 2018. In that, he has filed an application under Section 5 of the Limitation Act. By order impugned, the court had allowed the same. While allowing the same, the court observes that the applicant has filed this application with a delay of about 12 years to the date of instituting OS before the wrong forum, and further he issued notice to the corporation only on 6/12/2013. The same makes it clear that the applicant himself delayed the recovery of amount pending from the respondent corporation to his work done by him for a period of about 12 years. Accordingly, for the delay period, the applicant is not entitled for any interest on the balance amount. However, as he issued the notice on 6/12/2013, received by the corporation on 7/12/2013, from that date till the date of payment of the balance amount of rupees 3,13,952, the applicant is entitled for simple interest at the rate of rupees 6% per annum, and accordingly allowed the same. Agreed thereby, the corporation is before this court. The counsel appearing for the corporation submits that the works were done. Where are your objections? It is a contention of the corporation that the suit is not maintainable.
it has not completed its work as per.
No, dates, where are the dates? Where do you get the dates?
Lord, they have already objected.
Huh?
The aforesaid is already objected. Thereafter, Lord, they have
No. When you filed the suit, you must have stated the facts. When was the work? What has happened?
Page number 14, my lord. Actually, page number 14. 1-4.
When was the tender called for? Where do you get 14?
14, page number 14. 15/11/1999.
The what did you write? Suit is not maintainable. The petitioner, the plaintiff was granted the permission for construction of community hall under the tender notification of the Belgavi City Corporation as per its 6 work orders dated 15/11/1999 for a total amount of rupees 5,42,592 and completed the work within 1.5 years from the date of the said work. But he received a total amount of rupees 2,29,000 from the respondent corporation as per the work order. Hence, in view of the completion of the work at the beginning of the year 2001, the corporation is liable to pay 3,30,599 to him. And in spite of his personal approach, has to pay rupees 3,13,592. It is a case of the corporation that when, according to the petitioner, plaintiff, he had received an amount of rupees 2,29,000 from the corporation in the year 2001 till he filed the suit OS number 891 of 2014. He has kept quiet. According to the counsel appearing for according to the corporation, the suit is visibly their claim for recovery of the amounts is barred by limitation. The learned counsel for the corporation submits that the court, without considering any of these issues with regard to the entitlement of the plaintiff for recovery of the amounts that are due, and allowed an application filed under Section 5 of the Limitation Act without any basis. Learned counsel submits that the court ought not to have condoned the delay right from the year 2001 to 2014, even assuming that right from 2014 to 2018, he was pursuing the remedy before a wrong forum. He submitted that the order you is contrary to the settled law and is liable to be set aside. Next para. Then counsel appearing for the respondent plaintiff submits that there is no dispute about the fact that he has been granted the work and he has completed the work, and part of the amount is not paid to him, as he was having some personal difficulties and his wife is suffering from health issues. In view of the same, he could not file the necessary application, and in the year 2014 he had filed the same before the which court is that? Before the initially
second additional.
Before the
Second additional senior
before the second additional judge and JMFC Belgavi, he submits that the same was agreed, and the appellate court had permitted the petitioner, had directed to return the plate to be filed before the appropriate court. The counsel submits that the court had tried as he is pursuing before a wrong forum, that limitation, that part of the court has to consider the same, and the court, considering all these aspects, had rightly passed an order Hence, there are no grounds to interfere with the well-considered order passed by the court. Next part. Having heard the counsels on either side, that is the material on record. Undisputed facts are the petitioner, the plaintiff is a contractor, and the corporation has given a, by way of a tender, a work is allotted to him, and certain amounts were paid in the year 2001, and till 2013, either what has transpired between 2001 and 2013, nothing is placed, nothing has been stated. It is stated that for the first time in the year 2000, a notice was issued. Thereafter, he has filed a suit before a wrong forum, which was decreed, and later the appellate court has held that the first court has no jurisdiction, and accordingly permitted the petitioner to present the and accordingly directed that the claim to be returned to the plaintiff. Once he files a petition before the appropriate forum, in that RA, court has not discussed about the limitation and has only directed him to return the claim. Once he presents it before a proper forum, then when the cause of action arose, whether the claim is within limitation, or all those aspects that has to be considered. This court has perused the impugned order passed by the court. The court has failed to consider what has happened between 2001 to 2013 is such an inordinate delay, and the court has lost sight of the same and condoned the delay. When the law of limitation prescribes a particular period for doing a particular act, and when any application is filed seeking condonation of delay, the court has to consider the same. So that the court has to consider the same. The delay of 13 years, 12 years is an inordinate delay. In cases of inordinate delays, each and every day's delay has to be explained. But in this case, there is no whisper about what has transpired between 2001 and 13. In that view of the matter, this court is of the considered opinion that the court failed to consider, had condoned the delay without any basis. Hence, the order impugned is set aside. Yes. Yes. Yes.
Could it be has been compromised? This does not survive for consideration.
Indeed.
This petition is filed challenging the rejection of IF or condemnation of delay in appeal on original suit of petition. In every proceedings, the parties are compromised.
They are compromised.
That doesn't may be disposed of. This may be disposed of.
I'll just record that
Yes,
we don't want to
yes.
pursue this matter.
Yes.
The present revision is filed. Agreed with the orders passed in RA number 7 of 2017 dated 9/8/2009, passed by the senior judge at JFFC, Kusaki, on IA number 2 and 3. Like counsel for the petitioner submits that the suit is for partition, and in fact, the parties have compromised, and all the disputes between the parties are settled, and as such, the petitioner is not inclined to pursue the matter. In view of the same, the petition is dismissed as withdrawn. Give a memo better. Right. Yes. Next, and the memo is filed and the memo is taken on record. Yes. Yes, yes.
Number 3. Permissions Gulapano, Rashikar Gurji, correspondent 1 and 3.
Seek for days accommodation.
it was heard for some time already in the last occasion. I request for days accommodation.
Tomorrow.
Day after.
Day after tomorrow not possible. District on 28. No further adjournments will be granted.
Please.
At the request of counsel, the respondent. Next.
Still number 4. This is Somapur. This is Bawakar.
Maintenance is filed by the mother against two sons' minors. The other day, the matter has been heard by this honorable court, and
Shall get instructions about the arrears of maintenance.
please,
Only actually they were in arrears of around 1,10,000. But
50,000 has been-
50,000 they haven't.
deposited, and that it has been released in favor of the will.
That 50,000 is not.
No, apart from 50, there is 1,30,000.
1,10,000 is been informed by my account.
No, the petition is the mother. The respondent is the mother.
Mother.
Petition is the son.
And already 4 acres has been given to the respondent for
No, madam.
during the partition, my lords, the father has retained 11 acres.
Have you filed any documents before the court?
No, madam.
Kindly pass on.
Even if you pass over, how can you file the documents? File all the documents or something to show, so that the court can understand that she's having sufficient means. You file your statement of assets and liabilities, so that we'll understand what it is.
Till then, at least they may be directed to pay the maintenance.
Since
How much is granted by the court?
10,000,
10,000 is awarded, madam. So except the 50,000 that they haven't paid.
No, and 5,000, how much it would
From
be?
2022, the petition is.
Pay another 50,000. Then we'll decide when
I'm
we'll hear
ready
a
to pay
petition.
2,000 monthly. I will pay, my lords, because I am also living my livelihood on the basis of the coolie work, my lords.
That is
2,000 monthly. I am ready. to
false
pay.
statement, my
You
lord.
are
because-
paying or you have paid?
No,
I have paid 50,000 deposited before this honorable court order, my lords.
When is the date of order?
Date of order is
43.
from the date of petition it was ordered
Petition is dated
22/10/2022.
2/10,
22/10/2022 is the date of petition.
2022.
2020.
So it's 2 years.
It's 2 years. At the time of getting of the interim stay order, my lords, I have deposited 50,000 dollars. I have deposited on 17/8/2023.
Oh. Pay another 20,000.
50,000.
We'll hear the petition and file other documents also.
No, madam. That is false, madam. Because they work 1 acre agriculture land is there and they are cultivating the land and it is in RFA. They
Please
please
write
change
that
that.
counsel, the petition submits that. In the partition, the mother has got 4 acres of land. And the petitions are eking out their livelihood by doing coolie work. They do not have the sufficient means to pay an amount of rupees 10,000. 10,000 is granted.
10,000 monthly.
10,000 to the mother. Both the petitioner and the respondent shall file their statement of assets and liabilities before this court. This is matter on 2nd of December.
Yeah, at least.
And by the next date of hearing, an amount of rupees 10,000 shall be paid.
50,000 we ordered, madam. Because,
Let's see, pay 10,000 by that time. By that time, 10,000 shall be paid.
Given a order.
No, what is to be done now? I'm not able to understand. No. Why should we set aside that order? We'll decide it here itself. Yes. Call the next one.
Authorized still number 5. Santosh Kulmani. Bharti Bhatt.
That's 4 days time. File
Yes, sir.
necessary application.
Finally, 4 days time default order. Yes, next, 6.
Still number 6. Jia Gajiman. Deputy Litigant.
My lordship, we will send 1 second notice, my lordship. It was misplaced, my lordship. Kindly take time will be granted, my lordship. Please, my lordship.
You have an interim order?
No, my lordship.
They have an interim order? Stay is there?
No, no.
No. At the request of learned counsel, the petitioner, finally, a week's time is granted. Yes. Say default order. Yes. 7.
Number 7. Representation query.
What is special? No representation for tomorrow.
Seal number 8. Ashamt board. Nirmala. Division number.
ಇದು ಆಮತ್ತು ಸ್ಟೋರಿ ಕೊಟ್ಟಿದೆ.
What is that she saying? Huh? She wants her to be appointed.
She wants any custody.
That's what will appoint. Legal services, the advocates, panel advocates. What is this matter? Interim maintenance.
No. Here the marriage itself has not been proved.
Marriage itself?
Has not been proved. The respondent had been filing a series of cases against the petitioner. In the year 2007 only, the case filed by her in a restitution of conjugal right. The family court has observed that there is no relationship of husband and wife. The same has been.
What's her name?
Nirmala.
The respondent is present before the court, submitted that she is not in a position to engage the advocate, so and so is appointed to appear on behalf of so and so. List this matter on 28. 28. Yes. Intermodal is actually extended to that. Yes, next.
Seal number 9. Division number.
Challenging the order of interim maintenance granted by the family court.
How much is granted?
20,000 has been granted.
My lords, on the last occasion, after hearing for some time, had directed the petitioner to produce the income tax returns and the bank statement.
First of all, before that, what's your occupation?
But he is presently not occupied. Their entire family was earlier doing the pendal work. Whenever there are functions, they install the pendals and other things. During COVID, entire business went into loss. And this petitioner has been supporting only his brothers. 2 brothers are there and 1 mother. They have certain properties which they have rented out. Entire family is getting about 38,000 rupees rent. Out of them, the 3 families are surviving. And this petitioner is getting an income of 6,000 rupees as pocket money from his brother. There was no.
And what basis the court had granted 20,000?
There is absolutely nothing. That's what is my grievance before this honorable court. To come to a conclusion that 20,000 is required to be paid. The reasoning is not forthcoming to adequate.
Please come to that.
Yes, interim order. My lord should find on page number 41. Reasons from page 45. Last paragraph, may I read, Manoj? Para 8, it is the specific contention of the petitioner that her husband is carrying on contract work, and apart from that, he has other property, house, vacant place, as well as rented house, wherein petitioner is getting money for his subsistence, and is also to be noted that the petitioner has contended that because of animosity, he is unable to get employment and doing contract work independently of his brother, and in his assets and liabilities, he has stated that his income is nil, and that he is only working under his brother. It is to be noted that whereas on the other hand, his wife has mentioned that her husband is working as a pendal contractor, as well as having rents availed from the tenements let out and earning rupees 80,000 per month, which are denied by the respondent. But it is to be noted that in the light admitted, the relationship vis-a-vis the petitioner and respondent, considering the fact that he is only relying upon his brother, who are looking after the joint family affairs, and at the same time, respondent being duty bound.
Yes, where is the discussion? Just because they require, can he pay?
Lords, just I will brought to a kind notice of this honorable court that kindly at the paragraph number 13 at the petition, my lords.
Paragraph?
Paragraph number 13.
Page number?
There is no paragraph 13.
Of the objection filed before the file court, my lords. At page number 20, my lords.
at page number 20, wherein they, by objecting the petition in the trial court, they state that further it is submitted that the respondent has two brothers, namely Anand and Kumar Swamy, who are running their independent
Where are you
business.
reading?
No?
Page 20,
Page
last
20,
paragraph.
last paragraph.
Running page, page 20, last paragraph.
50 of the petition.
Mm.
Paragraph number 13. Wherein they state that further it is submitted that respondent has two brothers, namely Anand and Kumar Swamy, who are running their independent business since 1998, and the father of respondent was also doing the work till 2017. Therefore, the respondent having no any general knowledge, he worked under his father as a coolie. They state there as a coolie, and they
No,
submit.
if somebody is doing it
Well,
out of love and affection, how do you expect them to do it?
No, it is their own statement. And
They might have stated so. Now,
Well,
while determining the maintenance, court has to look at his capacity.
they have filed their own IT returns, wherein in 2017-18, he has filed, he has an income of more than 3 lakhs, 2017 and 18. And moreover, will file the school certificate, school demand.
Take that. What officer?
Wherein this petitioner has maintained this respond number 1 to 3. This respond number 2 is studying in the college. He has taken admission in the premier colleges and schools, and he has maintained from last 17 years. And now he is denying that he don't have any income. And their income
is that for this fee is paid by the petitioners?
No, my lords, they have not paid. The thing is that the 20,000 which has been granted, which includes this also, my lords. And in
60,000 rupees was paid by
in my
petitioners.
statement of objection, I clearly
So
mentioned
let
the-
them continue to pay the school fees then. We'll record that, let them continue to pay the school fees.
that he has to pay. It is not
As a father,
He's paying it.
he has to pay, and he has been paying is what my instructions are. Despite that, 20,000 per month in the absence of any.
No, we do
income.
like this. As far as the school fees and all, that itself is a very big amount.
Exactly.
Because two children. But then let him bear the school expenses, actuals, whatever it is, and we'll reduce the monthly maintenance.
I produced the rent agreement also. The rent agreement.
That also is paid. That also is paid.
No, he is not. The total amount, including the maintenance amount, is 20,000. In my statement of objection, I have narrated all the facts, my lords.
Have you obtained the divorce?
No, my lords, it is pending, still pending.
Who filed?
There is no petition.
No petition.
In fact, they are both well with each other. There was some minor misunderstanding. She went away.
And one more thing, my lord.
He is ready to
Take her.
good married life.
My lords, they state that he is taking a pocket money from his brother's money.
You answer to that, he is ready to, you don't file your divorce petition. And only you want maintenance, it can't be. If there are no reasons to stay separately, then go back to the husband, join the husband.
No, she is ready, madam. My lords.
He is also ready.
He is not ready to take that.
That's what he's saying.
They are stating here, but
Because when my
before a
wife-
family court, they are not ready.
Now we'll defer it to the mediation. Go appear before the mediation.
Can be done. Because
Can be.
in my assumption, it appears that this is a case where, and by virtue of
Considering
interim
the
order.
facts and circumstances and the fact that
Well, sir.
though the parties are living separately, so far they have not filed any petition for divorce. This court deems it appropriate to direct the parties to appear before the mediation center on 25th of November.
Well, that interim maintenance has been reduced from 20,000 to 13,000.
65% of the, and it is being
They are
paid.
facing, because
13,000.
What is being given is on the higher side.
well, the school fees also is pending. She is facing a problem.
Then
That is
you
the
pay
problem.
that.
Kindly direction may be given to pay the school.
No, according to me, it is already paid for the
Then
present
it's
academic
not,
year.
next para. Let counsel for the petitioner submits that the husband is the father is taking care of the educational expenses of the children. Let counsel for the respondent submits that as of now the school fees is due and the husband has not paid. By the next date of hearing, the father shall pay the school fees of the children. Yes.
Please.
Number 10, 840, Silvanta Satish. Reaction will open.
Bringing the legal aid.
Senior is
Fine.
out of-
Put up.
My lord,
Senior is in another court only. Kindly pass.
It's only the memo of reporting that the elaboration is not there. Yes, fine. Tomorrow. Process matter tomorrow along with the elaboration file. Yes, next. Give it to me. Yes, next.
Petitioner in this matter, but this honorable court earlier location was pleased to pass an interim order. Due diligence is not unable to pay the amount, but will not pay the amount.
So what is to be done?
My kind request to your lordship that was a weak accommodation, but finally.
When was the order 29/2024?
Indeed, Lords.
A week's time is granted for complying with the office objections. Next, even as per the order dated 29/2024 and 25/10/2024, the petitioner has not filed a memo to show that he has paid the amount, deposited the amount as per the interim orders passed with this court. Finally, even for this, a week's time is granted. This is matter after a week. By the time the amount is not paid as ordered by the court, the interim order granted will be vacated.
Please, Your Lordship, oblige.
DP करिएगा
Yes,
May please, madam. My lord, the petitioner here, he is the husband.
maintainability.
Maintainability, my lord.
How can you file an
Yes,
RPFC
yes,
against an interim order?
due to oversight.
The present petition is filed against an interim order. Office has raised an objection with regard to the maintainability. Office objections are sustained and the petitioner and the office shall return the.
May I file the memo for conversion?
You should have done it by this time. The petitioner.
No, ma'am, I will say now only I will file memo for conversion.
List this matter tomorrow.
Oblige.
By the request of non-counsel petition. Yes, next.
Oblige.
No reference. Yes. What is this memo for service of notice to? You've permitted to take notice on the council?
Yes.
Is it, sir?
I served on R1 and R3, Your Lordships. And R2 is none other than the mother of the petitioner number 1 here.
Why mother is a party to this?
Because she was also legal heir of the petitioner in OS number PNDC number.
She is yet to be served.
She is also mother and sitting in the same board with the.
But still, you know, when the notice comes, it has to be independent.
And one more suggestion. The counsel who is appearing for the petitioner number 2 is also representing the respondent number 2.
No, I think you have served on him.
Respondent number 1 and 3 have served.
No, the order might have been to serve on the council, not on the party.
Yes.
Then if for all of them are represented by the council, the petition permitted to take out notice on the council, appearing for the respondents. Then the same council is appearing for R1 to 3.
R1 is a different council and R3 is a different council. But the petitioner number 2 and respondent number 2 are same council in the trial court.
So, as per the order, have you taken out notice on the council for the respondents all 1 to 3?
1 and 3 I have taken.
2?
2 I have not taken.
That please take to the.
And what?
The petition submits that he'll, as per the order dated. So, as per the order passed with this court, he has taken out notice of the council for respondents 1 and 3, and he has also filed a memo to that effect. As far as respondent number 2 is concerned, he submits that he'll take out hand summons on the council and file a memo to that effect within a week. List this matter on 21st.
One submission, interim application has filed state. I would like to draw the Honorable Court attention to page number 115, wherein it was specifically observed that the matter involved in PNDC 3/2012 and PNDC 5/2012 The same fact is also involved in case number 417 by
No, no, no. If
2099, RA number
no, no, I
18.
think I have issued notice because the court is not inclined to grant any interim order. Let's,
And respondent 3 who is contesting, actually he has appeared to the council also, he has filed wakalat council.
where,
In the online status, it is showing the council.
Where is that? but then why his name is not reflected?
FU Patil for R3.
What is the name?
FU Patil.
Print the name of so and so, or list is marked tomorrow.
Because the thing is, when the court itself observes that the matter which is involved in RA also is the same fact in P&SC, and we have produced the original copy of the will in OS section.
We'll see. Once let one of them be there.
15th.
15th. Print the name of so and so.
Anyone like bill number 14? And we are
Short accommodation.
Another week's time is granted. This is marked on 21st.
Split.
Yes.
bill number 50. Kiran Kumar. Then a
Petitioner Manoj, as per order dated 22/10/2024, Manoj. Notice is served to trial court counsel, Manoj.
Please appear for respond number 1.
So now the process is completed.
Completed, Manoj. There is delay of 41 days, Manoj.
Ask him to get the book. You appear for 1 and 2.
No.
1, Manoj.
2 you appear for 1.
Only 1, please.
We cannot
Please.
delays. I number 2 of 24 is filed to condone the delay of 41 days in filing the revision, considering the submission, considering the reasons stated in the accompanying affidavit. The delay is condoned. No objections are filed by the respondents. Next, stay petition is pending.
Please.
Please.
Happy?
2 days accommodation.
Next week any date.
This is matter on 20th.
Please.
At the request of Land Council for the response petition for admission. Yes.
69, 17, number 18. Number 18. Number 1.
One.
Restoration petition was filed for restoration of regular appeal. That has been dismissed on the ground of delay of, there is a delay of 320.
Let's read that order.
Please. Kindly come to the reasonings. In page 65.
Why there is no attendant in the court all the time? Attendant should be here. Court attendant should be there, or the Jamaidar should be there. We can't search for them. Make sure that somebody is here. Yes, page number
65.
Yes, please read.
Please. Petitioner was appellant number 1, RA number 3 of 2012. It was filed by the petitioner hearing and respond number 2 to 4 hearing against respond number hearing as respond number 5 and 6 here. As stated, Supra, respond in RA 3 of 2012 was allowed on 13/12/2012. Subsequently, restored the wide order date passed in this will miscellaneous 4 of 2013, which was filed by respond number 1. Court notice came to be issued in RA number 3 of 2012 after its restoration to the appellant and respondent. The result of R6, namely the order sheet dated 27/4/2017 in RA 3 of 2012, reveals that the court notice issued to the appellant number 2, A, B, and C was served person. They have been treated as urgent. The result of order sheet in this petition reveals that respond number 2, 3, and 4 appellants the 2 below are served. They have not engaged any advocate to represent them. They have been placed ex parte on 29/9/2018. Petitioner has been served after restoration of RA 3 of 2012 to 5. court notice issued to in this behalf on dated 36/2000 has been received by the petitioner hearing on 8/7/2017. Subsequently, RA number 3 of 2012 was listed before the court on 27/2017, 27/7/2017, 31/7/2017, and 3/8/2017, 5/8/2017, and 9/8/2017. On all these dates, petitioner has remained absent before the court. Even respondent 2, 3, and 4 have remained absent on these dates. It is clearly noticeable that there were 4 appellants in RA 3 of 2012. Appellant number alone has filed a seeking for restoration of the same. It is forthcoming from the records that appellants 2, A, B, and C were also served. The reason for their non-appearance has been not been explained, nor they have stated anything in this petition. It is forthcoming that respondent number 2, 3, and 4 herein have not engaged any advocate in this petition as well. It is clear admission of the petitioner in cross-examination that respondent number 2, 3, and 4 are living together.
What is the suit for?
A suit for a declaration, partition and supplement.
What has happened to the suit?
The suit was partly declared. Share was not given to the plaintiff as properly. Therefore, I preferred a regular appeal of 2012. That was partly, it was ex parte declared. It was allowed. Against that, the respondent filed miscellaneous petition. In that, miscellaneous petition was also ex parte declared, and appeal RA 3 of 2012 was restored. But court notice with regard to restoration, not in the knowledge of petitioners.
Why, first of all, first step is not in your notice.
Yes.
That you are okay with that. So why are you not okay with the second step being not in your notice? How does it matter?
I had
First of all, it was allowed. First of all, there is an ex parte order.
First, not OS was after hearing
No, RA.
RA was ex parte, it was allowed. RA, it was allowed. My RA.
Your RA is ex parte.
Yes, it was ex parte. They filed miscellaneous 4 of 2012. That was allowed. And appeal was restored. The judgment ex parte.
So you are exceeded by the restoration.
No, not restoration. What happened, my lord, after that miscellaneous petition, which was, my lord, the ex parte decree passed in regular appeal, which was set aside and it was restored. It was restored. But after restoration, notice was issued
To you.
to me as my lord in the order. My lord, they say that in spite of notice being issued, you have been not appeared. Therefore, my lord, the appeal came to be dismissed for default.
When was it came to be dismissed?
Kindly, my lord.
Date, give the dates.
Yes, ma'am. Kindly. My lord, kindly, I have produced order sheet. My lord, in page, my lord, 33. Appellant and counsel action. Since long time appellant has counsel action. Reviews the record. It reveals that this case is restored as per order in the civil miscellaneous 4 of 2013. And order sheet also reveals that this court issued notice to the appellants as well as to their counsel. And notices are served upon appellant number 2 and their counsels.
No, anyhow, no,
Lordship,
your
even final decree has been drawn, Lordship, in the year 2022 itself, Lordship.
No,
who's saying this?
no
That's
say.
why, Lordship, the trial court has.
What are you doing without pursuing this matter?
Recently, I filed out the Wakala.
No, not you means your client.
Yes. My lord, the FDP is not, my lord, still it survives. Still it
In
survives.
the year 2022 itself, 8 December 22 itself.
That has been stayed, my lord.
Where?
In before, my lord, FDP court itself.
But mine-
No, my lord, there is a delay of 322 days.
Kindly have this message
No,
tomorrow,
we can
Lordship.
understand. But what are you doing from 2018 without no stay in this?
No.
You know, if there is no stay, what will happen? What are the steps taken by you? And you let the final decree proceedings to go.
As per my instruction.
So it has to, we have to look at it at every stage. There are lapses on your part.
Lapses is only one difficulty that arose was when the miscellaneous 12 of 2012 was allowed. That was not, that was also an ex parte.
No, let's forget about what has happened before
Yes.
the trial court. What is happening before this court? Which year is this?
2020.
2020, we are in 24.
Yes.
You know there is no stay in this.
Yes.
If there is no stay, what will happen? Now the final degree proceedings are already concluded.
As per my instruction that has been stated, I'll get instruction and then done.
I'm having order copy, Lordship, even one, whether wants to verify.
Get it? If final degree proceedings are concluded, we will not interfere. Get instructions. This is marked tomorrow at the request of the council this morning.
Tomorrow.
Yes.
Seal number 9. Ahmad, your answer. Number 19, Ahmad, your answer. That's respondent number 1. After respondent number 2.
This RPFC of 2022. And the matter listed on 1/11/2024, as there is no representation on behalf of the petitioner, this court has directed the matter to be listed under the caption for dismissal. Today also there is no representation. It appears that the petition. You appear in this? It appears that the petition is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Seal number 20.
Yes.
Which time I will subject of this?
A week's time. Default order, delete from the caption, dismissal. Yes.
Seal number 21. Finish this one. 21.
And council submits that they'll comply with the office objections during the course of the day. Delete from the caption for dismissal. Post after service of notice. Post after office objections are complied with. Yes, next 22.
Number 20. Praveen Kumar G. Kulkarni. Sir, Hagade. Sir, Hagade.
Which one? No.5.
On the last occasion. On an order dated 12/9/2024, the court observed that the amount is not paid by the husband as per the order passed by the court. Then when the matter came up on 5/11/2024, this court has directed the petitioner to file a memo for having deposited the monthly maintenance as ordered by this court. When the matter came up on 11/11/2024, there is no representation on behalf of the petitioner, and the counts for the respondent is present. And this court had directed the matter to be listed under the caption for dismissal. The petitioner, having obtained an interim order, had failed to comply with the same, and in spite of given sufficient opportunity, is not even appearing before the court. There is no representation on his behalf. It appears that the petitioner is not interested to pursue the matter. Accordingly, RPFC is dismissed. Next.
Seal number 20. Muslim G. Kulkarni.
2 weeks.
Why 2 weeks?
No, sir, I have misplaced the 5 weeks.
23 CRP. Finally, 2 weeks time. Default order. Yes, next. Delete from the caption for dismissal.
Seal number 24. Sankalwad. Sankalwad.
Yes.
During course of the
When council submits that will comply with the office objection during the course of the day, delete from the caption for dismissal. Yes, next.
10 days accommodation.
Why?
For compliance of office objection.
It can't be done in a week. It can't be done in a week.
Sir, I have some personal experience.
Finally, 10 days time is granted. Same default order. Delete from the caption for dismissal. Next 26.
Seal number 26. Santosh Kumar G. Nam. A part.
Perhaps it will be petitioned by the husband, challenging the return or passed by the family court judge. The family court judge had ordered 8,000 rupees,
How much?
8,000 rupees per month.
To the wife.
Why?
What is your income?
27,000 rupees.
Then
27,920.
27,000
920.
920.
22.
So why you can't pay 8,000?
I have to maintain my old age mother, one daughter, and
Daughter means your daughter.
my daughter.
He is with you.
Yes, ma'am.
Oh.
And the son who is pursuing his higher study.
He is also with you.
Yes, ma'am. We are 4 members.
So
Somewhat higher side.
28 divided by 5. How much will be your entitlement?
5,000 odd millions. 5,000
It
odd.
should be 4,000.
No, 5,000 odd. 20, 5 into 5,
He is having
25.
27,922. Round it up to 28.
20.
Hmm.
5,000 into 5,000, 25,000.
Hmm.
Even that.
No, children will have more
More
expenses.
expensive, but I don't have any income.
And you have no income, you have no liability to maintain anybody. He'll give you 4,000.
It is 5,000 millions, and furthermore, millions.
Children are studying. If you have to spend all that, what you will do?
May I make one submission further? The maintenance is granted from the date of petition, from the date of order, maybe from the date of petition. It has not been challenged by the. Even otherwise also, members, I am
How
entitled.
can it be?
Even otherwise also, I am entitled from the date of petition.
So you ask her. No, if you're
She is
entitled,
again,
you should have questioned it. You can't have an order in his petition. If you're agreed by it, you should have questioned it.
True, members, but this court has a power to.
No, but for that this court will not exercise. The agreed with the order passed, agreed with the order dated 5th June 2023, passed in criminal miscellaneous number 147 of 2022 by the Principal Judge Family Court at Garar. The husband is before this court. Parties are referred to as wife and husband for the sake of convenience. The marriage between the parties solemnized on 22/6/2014 at Garar as per the custom prevailing in the community. Out of the wedlock, they are blessed with a son and a daughter. Blessed with a son and daughter. It is the case of the wife that she is not able to maintain herself. Husband is working in NW RTC and is getting monthly salary of 40,000 to 45,000. And she sought maintenance of an amount of rupees 20,000 per month. The husband had filed his detailed objections. It is his case that he has to take care of the 2 children and an old age mother. The trial court, the family court, by order impugned, had granted maintenance of an amount of rupees 8,000. While granting the maintenance, the court observes that the husband himself has neglected the wife and has not provided maintenance to the wife, as a husband being an able-bodied person and getting handsome salary is under obligation to maintain his wife. And considering the salary of 27,922, the court had granted an amount of rupees 8,000. The land counsel appearing for the husband submits that both the children are, what is their age?
20.
The children are grown-up children, 20 children who are studying, and the petitioner father is taking care of their educational expenses and their maintenance. He has to maintain his old age parents or mother.
Old age mother.
Old age mother. He submits that the amount of maintenance of an amount of rupees 8,000 granted to the wife is on the higher side. Next one. Land counsel appearing for the respondent submits that the wife has no means to maintain herself and it's the duty of the husband to take care of the wife. And with the amount of 8,000 that is granted by the lower court is a reasonable amount and no grounds are made out seeking interference with the said order. He submits that the maintenance the court has ordered from the date of order, it ought to have been from the date of petition. Though, yes, the wife had not filed any appeal, this court has the power to alter the same and grant the maintenance from the date of order, next, from the date of petition. Next paragraph, having other counsels on either side, there is a material of record. The wife had claimed maintenance of an amount of rupees 20,000. According to according to her, husband is drawing salary of an amount of rupees 40 to 50,000. The trial court basing on the evidence had observed that his income is 27,922. Now with that salary, he has to maintain himself. He has to maintain 2 children and an aged mother. And wife had no other responsibilities to, or there are no other dependents on the wife, as rightly pointed out by the learned counsel. The amount of maintenance that is granted, looking at the salary of the petitioner, is on the higher side. Further, the contention of the respondent that without there being an appeal, now this court will alter the order of the court and will grant maintenance from the date of the petition, but not from the date of order. This court is not inclined to exercise any such jurisdiction, and the party, if at all is agreed, had an option of coming before this court, which the party has not chosen, and this court is not inclined to go into that aspect. In the light of the above discussion, the court is passing the following order. The order passed by the passed in criminal miscellaneous number 147 of 2022, dated by so and so, is modified, and the amount of maintenance from 8,000 to 8,000 is reduced to 4,000. As far as the amount, litigation expenses of 10,000 is concerned, this court is not interfering. Accordingly, the RPFC is allowed in part.
One application is pending for consideration.
What is that petition?
That modification of order, I have filed application, it is pending. In view of the disposal of that.
No, all that goes without saying. All pending IAS will go.
Oh, please.
Yes.
Finally, 1 week, madam.
Huh?
Finally, 1 week.
A week's time, delete from the caption for dismissal, for complaints of office objections, default order. Yes, 28.
This was heard on the previous occasion.
Where is he? No representation for the respondent. Let's this matter tomorrow.
Okay.
Delete from the caption for dismissal.
Okay.
Yes, 29. Huh? A week's time, delete from the caption for dismissal. Same default order. Next.
Justification for that was an order by the court below for 8,000 rupees.
How much is granted?
8,000 is granted.
What is your income?
My income is on the daily wage basis because he's a painter. He's been illustrated as a businessman, wherein they have staying in a very small house.
So how much you're going to pay now?
In fact, we are seeking for a permanent settlement before.
No. For the interim order, how much you're going to pay?
Any order by the court. Any order by
the petitioner, the counsel, the petitioner submits that is doing painting work, and there is no permanent a permanent income for him, or a specified income, and an amount of rupees 8,000 as granted by the court. The petition is not in a position to pay. Considering the same, they shall stay or call for the proceedings pursuant to the order dated so and so, on the condition that the petitioner shall deposit an amount of rupees 3,000 by 5th of every succeeding month and shall pay the arrears at 3,000 within 8 weeks. Same, either of the two is not complied with, the case stands vacated. The registry is directed to issue emergent notice to the respondent. And on such deposit, in all these matters, whether I tell or not, on such deposit, they are entitled to withdraw. Five, yes. 32. Delete from the caption for dismissal.
Needful is done, madam.
Huh?
Needful is done.
Needful is done. Then council submits that the needful is done. Delete from the caption for dismissal.
Please stand for the wife respondent.
Yes. Huh?
I'm ready to deposit, madam, 25%.
It's total arrears for us since the petition.
No representation. Before that, what has happened? Avoid service of notice. Any interim order in this?
No one.
Or no interim order?
No one.
Or 20.
Ready to deposit.
So, how much is granted by the court?
15,000.
has been done.
How much you are ready to deposit?
25%.
Why 25%? You should have been 15% there.
Now, arrears is 9 lakhs.
No, that also will.
Please.
What is your income?
No income, madam. Labor and yes.
What is the evidence before the family court? What is the evidence? What is income?
No, madam. He has not made any efforts.
Contested?
No, madam.
It's an ex parte order.
No, madam. He has contested. the
He has
matter.
not placed any evidence.
No evidence.
Then counsel submits that he has no income. In submits that he's a, what do you do?
The old is parents, madam. I'm ready to.
No. What do you do? To eke out is your livelihood.
Yes, please.
What is your occupation?
They allege that he is working as a mason. Labor.
Like counsel the petition submits that he is working as a mason and there is no regular income for him. The court has granted 15,000, which is very difficult for him to make, considering the same. When counsel applying for this warrant submits that the petitioner has not paid any amount right from the date of order, and the respondent is not in a position to maintain herself. Considering the rival submissions of both the counsels, they shall stay of all further proceedings on the condition that for proceedings pursuant to the order dated so and so, on the condition that the petitioner shall pay an amount of rupees 6,000 by 5th of every succeeding month, and at 6,000 the arrears shall be paid within a period of 10 weeks from the date of receipt of the copy of the order. Either an amount of rupees so and so is not paid, or the arrears so and so is not paid, the stay granted by this court stands vacated automatically. The respondent on such deposit, the respondent is at liberty to withdraw.
Please. There is a delay, madam.
Huh?
Delay, madam.
There is a delay.
421 days delay, madam.
IA number, so in IA number 1 of,
2024.
you file your objections.
That's-
You file your objections.
No, not.
IA 1 of 24 is filed to condone the delay of 421
days.
421 days. No objections are filed to the respondent. Considering the reasons stated in the accompanying affidavit, the delay of so and so is condoned on the condition of petitioner
Please.
paying an amount of rupees 1,000 to the
Please.
respondent within a period of 2 weeks.
Please.
Yes. Next.
I'm appearing for respond.
You appearing for the respondent.
Respond. Right, my lord. Order is passed in the year 2020.
He questions it in 2024.
24.
Hmm.
7 rule application.
The 1006, the RPFC is of the year
Yes.
2024. Huh?
Yes.
You have given RPFC. You have given the next file. Should give the before 5:34. The impugned order is dated
Dated, my lord, 37/2020.
37.
2020.
The impugned order is dated 30th July 2020, and the revision is filed in the year 2024. No, there is no IA for this.
Not IAS.
How much of delay?
Delay of 4 years.
Delay of?
4 years.
With the delay of 4 years, it is filed. When this matter came upon,
He's from Bangalore.
25/10/2024, this court has directed the petitioners to produce the translated copy of the plaint. And this matter came up on 11/11/2024. As there is no representation for the petitioner, this court had directed the matter to be listed for dismissal today. Today also, there is no representation for the petitioner, and counsel for the respondent is present. The petition is dismissed for non-prosecution. Yes, next.
Seal number 35. Another for a apartment. It is another.
6 for a week's time.
Huh?
6 for a week's time.
Delete from the caption for the. Is it? This is 36 or 35?
35.
Do that?
Yes.
As if there are no.
Amount has been deposited.
What are to be complied?
Order dated 24/4 euros.
Post RPFC for further orders for so.
Paid 2 lakh rupees amount in.
They are not deposited.
Deposited. Before this call, on 26/1/24.
No, for what you are seeking a week's time.
But it was issued for IF condemnation of delay also. 39 days delay was there.
Notice is also ordered.
Ordered, yes.
Where is the counsel? What is the name? AD?
AD Nadaf.
How much is the delay?
39 days.
IA number. Where is that only?
IA 2 of 24.
I number 2 of 24 is filed to condone the delay of 39 days. No objections are filed by respondents. With the reasons stated in the accompanying affidavit, delay of 39 days is condoned. Next step. As per the order passed by this court, when counsel has deposited the amount, the respondent is at liberty to withdraw the same. Yes, next.
Please.
Seal number 36. Chetan Gurwani.
Here for the revision petitioner. For 2 weeks time to comply in your still when it
2 weeks time for complying with the office objections, relief from the caption for dismissal, and even the above matters also. All are in dismissal. When they appear, delete from the caption dismissal.
serial number 39 is also connected to matter.
39 is connected to this. Post along with 39, delete from the caption for dismissal. Even for that also, complaints of office objections. Yes, next. 37.
Not the office objection. 1 week time to comply the office objection. Sure.
And you have to file the LR petition also.
LRs of respondent number 3 and 4 are the LRs of 4.
Then you have to, then for that also memo should be
We have
filed.
filed the memo reporting that members. We'll also file that.
Like counsel seeks a week's time for complying with the office objection. Next, a week's time is granted. It's MD default clause. It is stated that the first respondent is no more, and respondent 2 and 3 are the legal heirs.
Yes,
Legal heirs of respondent, and to that effect, they'll come up with a memo. This is matter after a week. Yes. 38 and delete from the caption for dismissal. 38.
Dharwad. 38.
Written by the wife and one daughter. was in respect of right, the petition came to dismiss. Was a grant of maintenance. In respect of petition number 2 also, 3,000 is awarded.
So you are on dismissal or you are for enhancement also?
Dismissal as far as
Why it is concerned?
one is concerned, enhancement.
On what ground enhancement for the enhancement also is sought? How much you have, how much is the maintenance you have claimed before the court?
What's the 20,000 by the right plots and 10,000 to the children. Initially, plots the petition was filed by
Children, 2 children.
Plots in this petition only one child. As I stated, initially the petition was filed by the wife and 4 children. But after the institution of this petition, the matrimonial home and the maternal home of the are in 400 to 500 distance. This husband takes away these 3 children, only leaves the handicapped daughter with the wife.
How much is the income of the husband?
Pardon?
How much is the income of the husband?
He has he's an agriculturist. Totally owns 10 acres and 1 tractor, and is growing irrigated crops.
And he is taking care of 3 children.
Sorry?
He is taking care of 3 children.
3 children. That is there not after the institution of the petition. Then he takes back.
The fact remains
And in
is
fact,
3 are with them, 3 are with them, and 1 is with you.
one handicapped.
Now let us see what is the court. What is the observation of the court on your entitlement?
Please, no, sir. So far as the right is concerned, it is right under point number 1. What's the contention of the wife for living separately from husband is that. What's the husband was having an extramarital affair with one Somoa, and since both of them was made an attempt to do away with her life, and also she was admitted to the hospital, and thereafter what in the petition
Divorce is obtained.
Sorry?
Divorce is obtained.
No, they have obtained an decree of restitution.
Who obtained?
The husband has obtained.
Then
What's the very contention of the wife is that since
no, all those things are not open to you now. If the restitution is a degree of restitution is there, if there are reasons, you should have questioned it in appeal. You have not questioned it. So once it is there, how are you entitled under 125? On the face of it, it is there to show that you have deserted the husband.
My humble submission is that in the background of the present things, if any degree of restitution is obtained, it's one of the grounds for taking divorce from the husband.
No, that is also one of the grounds for 125 because now a court in a competent court by evidence by looking at the evidence have held that he is entitled for restitution.
In fact, as per my instruction, that the restitution was not contested.
That we cannot go into it. That we cannot go. Which you have chosen it, having understanding the consequences of it. Now, coming to what is your income? About enhancement to that child, what is your income?
Regarding that, only we have stated that an agriculture.
You are having 10 acres of land. What is the income or derived out of that? Please get instructions. Please get instructions tomorrow. We'll pass orders. List is as started.
In para number 27 was.
How much is the income?
It has come.
How much is the income?
May I read?
Para number?
27 of the order. Page number 48, page number 48, in page 31. Para number 27 of the order. 27.
Yes.
As ordered by the learned advocate for the petitioner, RW1, that is the husband, has admitted the RPFC extract of the land bearing survey number 5 or 1 measuring 1 acre 35 hectares and 25 bar 2A measuring 5 acre 24 hectares, marked as exhibit T2, T3 standing in his name, and survey number 38 bar 1 measuring 3 acre 18 hectares standing in the name of father at page number 2 in para number 1 of his class examination and at page number 3 in para 2 of his class examination.
What has come? Income in terms of figures.
The court comes to the conclusion that since he is having a tractor and is growing sugarcane crops and irrigated crops, and considering that fact, the court comes to the conclusion that 3,000 would be.
So, if you say that that has to be enhanced, unless until you tell the court what is the income derived out of it, or there is something on record, how can the court enhance it?
But so since it's an agricultural income, we have,
That's why the court do not know how much it fetches.
since the agricultural operation is done by.
Yes,
Please, but no specific income they have stated.
not
And
they have
it's a-
stated, you have also contested, you should
Please,
say,
please.
then counsel for the respondent shall file a member, an affidavit shall be filed before this court by the husband, what is his yearly income and the expenditures. This is matter on 4th of December, delete from the caption dismissal. Yes, next.
Weeks of time also for compliance of.
Yes, a week's time, delete from the caption for dismissal default order. Next.
Seal number 41.
Same. A week's time, delete from the caption for dismissal default order. Yes.
Cited for respect. The petitioner has filed application as 91. Submit the documents. I need to file objection to the applications.
Yes, file it here.
Yes. The very same application is filed before the trial court, we are rejected. Again, he has filed application in this RPFC.
How can he file an application before this court now?
My lord, I filed the application before trial court. In no time the final judgment was passed. The time was not sufficient, opportunity was not given for me to file the appeal against the said applications. Hence, those are the applications which are pertinent for rendering the judgment.
Let's see what is that application.
Application for summoning the two documents. One is
No, we will summon. No, we will summon and we will take the evidence now here.
no, my lord.
Then it has to
One
be
is salary
remanded.
slip.
Then it has to be remanded for evidence.
Salary slip and his account details.
That you can file. You're supposed to
Document
file your salary certificate. It is not something for that
No,
you need to file objections.
That my contention that I am not working there.
That you tell the court.
I filed in affidavit. It is filed before the trial court.
My lords, those applications were not properly considered by the court below. And no sufficient time was provided for me to at least file the.
No, all those IAs will be considered with this court. Now you will tell the court that he is working. He will say he is not working. No, let us call the witnesses here and let the court cross-examine. You examine court record everything. How is it possible?
My lords, I want to file the affidavit of the appellant. She is sure that she is working in that place.
The probabilities, he is talking about the probabilities. The evidence.
You already filed an affidavit.
Yes. And
That's sufficient. Yes, file an affidavit, then if you say that it is not, then you initiate appropriate proceedings against him.
No, one more thing, madam.
If you say, if you have my number, file an initiate appropriate proceedings.
One more submission. My party is ready for one-time settlement. And I have given an offer to them.
How much?
5 lakh rupees. Because both are educated and.
Just now you have informed him.
Yes, morning only I informed.
Then counsel for the respondent submits that his client is ready for one-time settlement and is ready to pay 5 lakhs. And the same is communicated to the land counsel appearing for the wife. And the counsel submits that he'll get instructions in that regard. List this matter on 20th.
Please, madam.
This is matter on 19th. Delete from the caption for dismissal. Yes,
Number 43.
a week's time, same default order, delete from the caption dismissal. Next.
Number 44.
A week's accommodation.
The week's accommodation, delete for caption dismissal, default order.
I appear for petitioner. Office has raised an objection regarding, I have given a submission, but this matter arises out of execution petition. Assistant Register of Cooperative Societies passed an order against the principal debtor as well as the sureties. Sureties are not made as parties, they are not required. I have given note below the cost set.
Let's see. Where are the objections? Which objection is this?
Serial number 4.
JDRs 2 and 3,
Yes,
if they are
I
not
agree.
made parties,
Yes.
council has filed and again, office objections are raised. Now,
On
that, IA number 1 or 24 to be
Objection.
paginated
Yes.
and
If
index
it is
to
application is
continue.
paginated, the office says it has to be continued. Application is paginated, index is also.
And index continuously, that you cannot have any submission on that, you have to
I
do
will
it.
not, if the application
Next,
is,
to be dated and signed by the council, that also to be done.
that
Para
is
number
done.
1A to be corrected.
That is done. Only one.
4, where is the
Yes,
cost
then-
title, let us see.
Please.
Why you have not shown them?
JDR number 20. They are not required. My lord, they are
That's
the-
what, if they are not required, first of all, as it is, cause title should be as it is. Then the note should be that so and so, they are not proper and necessary parties, and you are not claiming any relief against them. That you have to, but the cause title should follow. Do it.
Please.
The office objections are sustained. Petitioner shall comply with the office objections within a week. In a week, default clause, yes. Delete from the caption of our dismissal.
Please.
Number 46, Shainapur. Sangli. Shainapur, serial number 46.
The matter is placed before this court as a petitioner failed to comply with the office failed to pay the process. On 11/11/2024, as there is no representation, this court had directed the matter to be listed for dismissal. Today also there is no representation. Accordingly, the petition dismissed for non-prosecution. Yes, next.
47, Manjunath A. Kariganath. Serial number 47, Manjunath Kariganath.
Same, the matter is listed for, even before the registrar also, there is no representation. And office objections are not complied. Matter was directed to be placed before the court. Even before this court also, there is no representation. And this court has directed the matter to be listed today at the caption for dismissal. Today also, there is no representation. It appears that the petition is not interested to pursue the matter. Accordingly dismissed.
Number 48,
For non-prosecution. Is 48?
going to 40. Serial number 48. Going to 40.
Matter came upon 11/11/2024. As there is no representation, the matter is directed to be listed in the caption dismissal today. Today also there is no representation. It appears that the petition is not interested to pursue the matter. Accordingly dismissed for now prosecution. Yes, next.
Admission with serial number 49. Ganga Bachche. To just regain.
No representation for dismissal tomorrow on behalf of either of the parties. Yes.
Serial number 58, serial number 51. DS Nandi.
Yes.
The plaintiffs wrote a petition. Food for wrote a rejected wrote a tenant law. So that you also can see what the issue framed of the trial court law. Page 16 wrote a issue frame.
Where is the order improved?
Wrote a page wrote a start from page 10 to
Court holds that the court is not within the jurisdiction of the court.
exactly not there. So far as determination of termination of tenancy is concerned, what it is held in my favor. The court has taken about do that. But New of Article 4 C block. The court has no jurisdiction to not write this block. You also can see the reason block of this block.
No, we'll go to that particular reasoning given by the court. Which para of the order? Reasoning that the court has no jurisdiction.
Exactly. About page 24, point number 2.
Please read.
Yeah. Point number 2.
Yes, yes.
It is to be noted that the suit is filed on small cause suit for rejectment of the tenant after termination of tenancy. Therefore, this is termination of tenancy is concerned, it is held in my favor. That is
Let's
section
read.
1. Therefore, it is relevant to note that under section 8 of the Karnataka so and so, it is stipulated as follows. Cognizance of the suit by courts of small causes. A court of small cause shall not take cognizance of suits specified in the schedule as suits accepted from the cognizance of the court of small causes. Thus, the schedule of the Act contains a list of suits highlighted in the paragraph 25, which are not within the cognizance of small cause causes. In the same schedule, the subclause number 4 reads as follows. A suit for possession of any property or for the recovery of interest in such property, but it starts from my case, but not including a suit for resentment where the property has been let under lease or permitted to be occupied by written argument so and so and so. Then the court of small causes would be competent to take cognizance of suit for the rent of this property. The only substantial issue arising, C is very important. For the decision is as to whether the lease has been determined by efflux of time, limited thereby, or has been determined by notice in accordance with the law from the time in force instead of such lease. The permission of occupancy has been withdrawn. C has been complied with in my case, and that is the findings on issue number 1 also.
Then let's see.
Then the next paragraph. Paragraph 6. Thus, a suit for possession of any property or any interest therein is not within the cognizance of court of small causes. I don't know about the reason why not the court has said.
Please come to the plaintiff. Please come to the plaintiff or your petition.
Exactly. I have produced along with the petition. So, yes, page 30 starts
Page 30. Yes.
Page 30.
Come to the relief portion.
Relief portion from page.
You want to use?
Yes.
Eviction.
There is a great the vacant position of this property from the difference.
You want the premises to be vacated. Ejectment.
Exactly. So there is no prohibition for the small cause courts to try so far as this relief is concerned. But what the trial court has not actually gone into
No, if you look at Para 12.
Please.
Para 12.
This is the suit for possession of suit property by an SR against lessee. When the annual rent of rupees so and so 600, hence the suit is valued for purpose of so and so. And the additional court is
so, because you said that the suits for possession of the suit property,
yes.
A court felt that you fall under that exception.
No court not. The reason for not holding that the court has those restrictions is different from rulership and disseminate. Not on that ground road, it is ignored.
Then please read further, 26.
Yes, the paragraph 26. Thus, a suit for possession of any property or any interest therein is not within the cognizance of small cause. However, exception to this rule is a suit for ejectment falling within the A to C mentioned supra. All the said conditions must be fulfilled to maintain the suit for ejectment before small cause. It is maintainable but subject to compliance of A, B, C rule. What the court said. The convention used in conditions A and B supra in the certificates which indicates inclusiveness of other succeeding conditions as well. Thus, the clause A to C are interconnected but not independent. Thus, a suit for ejectment in respect of property, the 27 and 28 are important.
No, what it says is because it is and is there. So all the three has to be fulfilled.
Has to be complied. Then the paragraph 27. Thus, a suit for ejectment in respect of property let under lease, either written lease or oral lease, and for rent of the property, and where substantial issue involved is only whether lease is determined by efflux of time or by termination notice, can only be tried and disposed of by this small cause. Under such circumstance, whether the present suit falls within the category mentioned above has to be considered. Then we will exhibit P5. The reference is there for the lease deed. Specific clause is so and so. Toward married
yes.
Canada.
Yes.
5 ವರ್ಷಗಳ ಅವಧಿ ಮುಗಿದು ಕೂಡಲೇ ಆಗಿನ ಕಾಲಮಾನದಲ್ಲಿ ಆಸ್ತಿ ಕಿಮ್ಮತ್ತು ನೀವು ನನಗೆ ಕೊಟ್ಟಲ್ಲಿ ನಾನು ಕಟ್ಟಿಸಿ ಇಮಾರತು ನಿಮಗೆ ಬಿಟ್ಟು ಕೊಟ್ಟು ಆಸ್ತಿ ಜಾತಿ ನಿಮ್ಮ ಜಾಗ ನಿಮ್ಮ ಕಟ್ಟಕ್ಕೆ ಬಿಟ್ಟು ಕೊಡುತ್ತೇನೆ. After the expiry of note period brought, whatever value is there brought in respect of note, the constructed portion note structure. I am ready to brought due possession, vacant possession note, that is what this exhibit note P5 indicates. Then
What it says, sir, what it says? After the expiry of the lease period, I'll give vacant portion of the property.
Subject to not payment of the value of the structure.
You have to pay the landlord has to pay the value of the structure to the tenant.
Exactly. Then note, para 929 note. This is obviously the reason why the court said I have not jurisdiction. Thus, in this suit, for rejection, the compensation to be awarded to the defendants towards the present value of the building situated in the property, it is necessary to be granted to other rejectment. For awarding such cost of building existing in the property, it is necessary to appoint a technical person in the field of civil engineering who can value the current value of the building existing in the property. It has to be done. It would require asking of the preliminary decree for rejectment. However, the suit being only small for suit, but not an original suit, passing of preliminary decree might not be possible in the suit. The scope of present proceedings exceeds simple question whether this is determined by effect of time or permission.
Yes. Notice to respondents. This is directed to the merger notice to respondents. Yes. Notice. Yes, next.
Number 15. Once again, page 47.
Yes.
Yes. It was agreed on last occasion that we would have this matter disposed of.
Yes.
Petitioners before this one assaying the order of rejection of an application.
Yes.
Filed for rejection of the claim under order 711.
What is the suit for?
Suit is one for declaration and injunction, and in the alternative for possession. The suit filed in the year 2020 in all makes a prayer for 17 leaves. And
the suit is filed in the year
2020.
2020.
Yes.
Now, before going into that, first let's see your application under 711.
Page number 30.
Yes. Please read.
Yes. The affidavit filed in support of the application,
Yes.
I am coming to paragraph number 1. Plaintiffs have filed this with the suit with some grand designs of extortion. The plaint presented is ingeniously drafted with deceitful suppression of facts and players which are not maintainable in law. The suit asserting the transfer of title and possessory interest over partitions of erstwhile RS number 1019/1 of Belagavi, which happened nearly 90 years ago. The plaintiffs claim that they were unaware of the existence of suit property itself, which we cannot revive limitation insofar as that claim is concerned. The land in question has undergone change in the land use, converted into commercial use, was divided into several parcels about 4 decades ago. Thereafter, the property has changed hands in divided forms and proportions several times. The plaintiffs, although prefer to term the sale deeds, which are as many as 10 in numbers, as illegal, but fail to seek a declaration of title.
Please come to the plaint. Plaint. Where is the plaint?
Plaint can be found at page number 36.
in the second week of May 2019, so and so. That's a cause of action they're showing.
That is what is stated in that column.
No, then we'll come to the release, what they sought.
Yes.
Come to page 57.
57. Now the first relief is a decree declaring that the alleged city dated 30th of March 1991 in respect of western portion of so and so, allegedly executed by so and so in favor of document number 11, and subsequent compromise decree passed in OS number 123 of 91 and final decree in 9 of 2002 is illegal and not binding upon the plaintiffs. And this proceeds.
So all the sale needs to be declared.
Yes.
That's not binding on them.
Yes, ma'am. And kindly come to page number 59, trial K. A decree for mandatory injunction against the defendants number 15 to 18 to demolish the illegal construction made in city survey number so and so and put the plaintiffs in possession of the said properties. This is a cancer hospital.
What is the consequential relief they are seeking? Consequential injunction?
Consequentially, is what they say is a decree for permanent injunction restraining so and so from changing the nature of the suit property by trespassing, and a decree for permanent injunction restraining so and so from alienating. And finally, an alternative relief is in the event if the Honorable Court holds that the plaintiffs are not in possession of the suit property, in that contingency, the actual vacant possession of the suit property may kindly be awarded to the plaintiffs.
Why the court should come to the conclusion? You should tell the court whether he is in possession of the property or
Honestly
not.
speaking, that should have been the pleading, Manoj.
No, when they say that the sales have been done so and so, so and so, and so many sale deeds are executed, and if they are aware of it, and if they are in possession of the property, what did they say? Please come to the paragraph. Their case.
Yes. Now I take a lot to. There is a description of the properties given in the beginning of opening paragraph.
Is it its case that the fraud is paid?
It is only in general fraudulently, that is what they are. Paragraph number 3 of the. Now I'll take notes to.
What is the age of the plaintiff?
Plaintiffs are 10 in number.
85 years, 60 years, 58 years. If it is something has been done in 1925, some of them are not even born by that date.
No.
My lords, I request my lords to come to the para number 3 of the claim at page number 45.
Read the para 2 also.
Yes, my lords. Please. The plaintiff respectfully submits that the predecessor of the title of the plaintiff has filed a suit for partition and separate possession against the Ibrahim Gauss of Mujawar in OS number 495 of 25 before the Honorable First Class Sub Judge Belagavi. The said suit came to be declared, and the pursuance of the said decree said Sri Ibrahim Mujawar had filed an execution petition in 517/1928 for awarding the half share in the family property. Further submitted that in pursuance of the preliminary decree of the Honorable Court was pleased to effect a decree of granting 8 acres 2 guntas of land in RS number 119/1. It is the subject property of this suit, my lord. Belagavi, to share of Ibrahim Mujawar. Out of the entire land measuring 16 acre 19 gunta, the plaintiff submitted that on obtaining the possession of 8 acre 2 gunta, said plan as per the decree in OS number 495 or 25, the said Ibrahim Mujawar got recorded his name by submitting Hissa number 12 to competent authority. The mutation entry number 1730 came to be effected on the same has been certified on 17/7/1931. To that effect, it is further submitted that as per the above said mutation entry, the name of Ibrahim Shah Mujawar has been recorded in the extract as the owner in possession of the above said land. It is further submitted that the court officials have handed over the possession of the property allotted to the Ibrahim Mujawar. The execution petition bearing EP number 517/1928 came to be closed as fully satisfied on 21/2/1932. It is further submitted that the partition decree referred above also recorded ME number 1471, and further in para number 3,
the plaintiff submitted that Ibrahim Mujawar is a man of simpleton nature. He is not aware about the worldly affairs and taking due advantage of such a situation. It appears from the revenue records that one Subbarao Balappa Naidu created a false fabricated document styled as court auction, referred to a document alleged to be passed in EP number 39 1935. It is 38, my lords, by mistake 386 has been done. And 39 by 40, and got recorded his name behind the back of the Ibrahim Mujawar. And under mutation entry number 3829 dated 3/8/1940, my lord, and which is alleged to be certified on 26/1954, my lords. And the execution petition, the said Subbarao Naidu has been referred. It is not in respect of the subject line, my lords.
So,
and said document I have produced before
two generations passed by, and suddenly after the third generation came to know that somewhere like the property was in their name.
Yes, my lord. My lord.
Then you should have sought for a declaration that you are the owner of the property. Where did you sought?
My lord, I am the owner of the property.
As of now, everything is, so many sale deeds have come. So many, according to them, they have purchased the property by way of a registered sale deeds. So we should seek for declaration.
My lord, my submission, sir. My lord, we have never lost our title, my lord. Because
come to patient.
My lord,
come to verify and read it. Verify.
The plaintiff respectfully submit that the Katal Sahib Mujawar died on 1996, leaving behind him the present plaintiff as a legal heir. They have inherited the ownership right over the properties held by the Katal Sahib Mujawar during his lifetime. It is respectfully submitted that the plaintiff were also unaware about the properties of the family, and they come to know about the illegal entry.
First question, you are not in possession of the property. You are not aware of it.
My lord, it is a barren land. It is not a cultivable land, my lord. It is only using for grass cutting, my lord. Now also it is a vacant land. No one is in possession of the property.
No, if there is a registered sale deed, what
my lord, it is on the basis of only mutation entry, my lord.
But there are sale deeds. There are sale deeds.
Yes,
but on which year?
My lord, the mutation entry which has taken place in the year 1940 and
so you will question it, the mutation entry which is a public document in the year 1940, will you come to the court in which year?
My lord, thereafter, and in para number 4.
I read for para number 4. I have come to para 5.
Yes, my lord. In a mutation entry.
Now there is one person, whatever that original 1925. His son died. His son's son, he died in 1996. Finally, the great grandchildren of so and so will realize that something has happened in 1949, and 1949 entries are changed. Now you will file a suit in 2020. 2020.
No.
And that too, what is the suit? You are not in possession of the property, and so there are sale deeds which presupposes that they have been in possession of the property because the documents are in their favor. You don't seek a declaration that you are the owner of the property, and so and so is not, and that sale deeds are not binding on you because you have to file. Then the court fees has to be paid.
My lord, my submission, my lord. The plaintiff has unaware about the illegal entries made by the Subbaiah Naidu one only on the mutation entry.
These are all public documents. Those are all public documents.
My lord, that's what I have brought the notice, my lord. In the year 1944, there is one more mutation entry after the death of Ibrahim. His son has got mutated his name, my lord.
1944 entry, how can you question in 2020?
My lord, in the year, that's what I have brought the notice of this honorable court, 3/8/1940, for on the basis of that.
Let us accept it. Let us accept it. Something has happened. Let's accept that.
Yes, my lord.
So whenever you suddenly awake from this your deep sleep, then the cause of action will start from that day. That to all the documents are registered documents. Entries, mutation entries, public document. What Section 3 of the Transfer of Property Act says? Yes, read further for para 5.
The plaintiff as his legal heirs, they have inherited the ownership right over the properties held by Katal Samujara during his lifetime. It is further submitted that the plaintiffs were also unaware about the properties of the family and they came to the knowledge illegal entry pertaining to the property in the month of 2019, and immediately they have obtained the relevant document and came to know about the illegal entries made in the revenue authorities on the basis of false and fabricated documents of the families. The depend number 129, the plaintiff further submitted that on verification of the record pertaining to the acquisition petition referred in ME number 3829 in favor of the Subbarao Balappa Naidu, it reveals that there is no such order of auction either against the Katal Sahib Mujawar or his father Ibrahim.
Unfortunately, how this plate is drafted? Come to page 47, para number 6, last 3 lines. Isn't it misrepresentation of facts? The plaintiffs submit that the sued properties of open spaces, thus the plaintiffs are in possession of the sued property as on the date of the suit, about the properties which you don't even know till 2020.
My lords, there is a number of family properties are standing in the name of the Ibrahim Mujawar and Katal Sahib Mujawar, my lord, in the Belagavi.
Now you will dig everything.
No, my lord. And it is a barren land. It is not for the cultivable land, my lord.
Yes. Still allow the petition.
My lords, I request for a 2 days time. In respect of declaration, I will.
These kind of suits are entertained. There is no end for the litigation.
My lords, in respect of.
There is something called a Limitation Act. There is something called.
My lords, 17 of Limitation Act is very clear because there is a fraud has been committed by.
No, fraud vitiates everything.
Yes.
But that what is that? When did you come to know? You say that so and so died in the year 1996. Then you come to know about, you started digging all this and you came to know. You do not even say when is that date. Isn't it? It's for you to plead. They played fraud on you. You came to, at least that cause of action starts running from the day you come to know. According to you in para number 5, you are saying that 1996 somebody died. From that you have come to know about all the transaction that has happened. That means you have been knowing it from that time. So why did you question it in 2020?
My lords, it is the first time I have got the knowledge about the illegal entries in respect of the suit. In the year 2019, my lords. Thereafter,
No,
immediately.
you said you talk about 1996. Come to para number 5.
On death of Katal Mujawar, we have not got recorded our names from on the death of Katal Mujawar, my lords.
That is after 2 generations. 2 generations.
My lords,
Whatever instructions you want to get, this is smarter tomorrow as part-heard.
day after tomorrow morning, I request for that.
Day after tomorrow not possible. List it on 19th as part-heard. For the counsel part, at the request of counsel for respondent. Yes, next. Yes.
I would like to make a submission on the objection filed by the respondents. They contended that she is resident of Shikaripura. She is residing there. She is residing with her sister at Unnalli. So she has filed criminal misdemeanors before Unnalli court. And in objection they have showed the FIR, Your Lordship, where it states that the accused number 1 is a respondent.
So no. Before going to that, let's understand. Where is the MC pending now?
MC is pending before Bagalkot.
Bagalkot, where it has to be transferred?
From Bagalkot to Unnalli.
Unnalli. What is their objection?
Their objection is that she is resident of Shikaripura.
Where is Shikaripura? How much is the distance between Unnalli and Shikaripura?
It is near Shivamogga.
What is the distance? Not the Aadhaar card. You're saying that she filed in Shikaripura.
Yes, sir. And even the incident has taken place at Shikaripura. Also, she has made complaint before the Shikaripura police station.
What complaint?
498.
You were residing together in Shikaripura?
Yes, Your Lordship. In FIR, Your Lordship, it is shown
No, it was a matrimonial home.
Yes, Your Lordship.
Then?
He was residing at Shikaripura. Now he has transferred from Shikaripura to Ramdurga, Your Lordship. But he has filed MC petition before Bagalkot.
34 kilometers is the distance.
Bagalkot he has filed.
Yes,
you are
sir.
saying where is he residing?
Ramdurga, Your Lordship.
What is the distance between the two? The immediate family court is Bagalkot only for Ramdurga?
No.
It's 245 kilometers.
Then why did you file there when you are a resident of Ramdurga?
I'm a permanent resident of Bagalkot. I'm residing, my father, mother, and all resides in the Bagalkot.
Then what is this Shikaripura?
Shikaripura, I used to stay over. I'm an assistant high school teacher. Presently, he was transferred to Ramdurga, Belgaum. Produced the ID card also, and the.
What is the distance between Ramdurga and Unnalli?
Ramdurga and Unnalli is
255 kilometers. 245 kilometers.
Anyhow, the case being at Bagal court is of no use because you are not there. You are in Ramdurga working somewhere. So why do you travel to Ramdurga to Bagal court? Instead of that, you travel from Ramdurga to Munali.
My understanding is that the present petitioner is permanent resident of Chicago. I have produced the Aadhaar card, voter ID, and it
was a matrimonial home because she was staying there. Now she has the disputes. You left, she left. Now she is in Unali.
And she filed.
Anyhow, you cannot have any difficulty because you are not a resident of Bagal court at all now.
At present, I am not.
Then your transfer at least.
We are seeking transfer of that miscellaneous also.
No, at least 3 years you will be there in that Ramdurga. So by the time this case will be decided.
And my humble prayer is that already the principal bench has granted stay on the criminal proceedings, which has been initiated.
That will be taken care of. That will be taken care of.
The present petitioner is a government employee.
Where is she working?
Present.
Yes, I said you are in Ramdurga.
You will not get the
any children out of the wedlock?
No.
Agree with the orders.
We will be facing some difficulties also regarding to also to attend the court.
You have difficulty. What about her difficulty?
It's 34 kilometers.
From where to where?
Online to Bagal.
And you? And you?
248 kilometers. From Ramdurg to Hanal.
Anyhow, you have to travel from Ramdurg to Bagal court. Are you not supposed to travel? Court will come to you. You have to travel. When you're traveling till Bagal court, why can't Unali? Let it be somebody's convenience. Agreed, the present petition is filed. Seeking transfer of MC number 26 of 2023 pending on the files of Principal Judge Family Court, Bagal Court to Principal Judge Family Court, Davangere. You said, what is it? You wanted it from to Davangere?
Yes, sir.
Unali is? That's the next family
yes,
court. Family Court, Davangere. The facts of the case are the parties married on marriage was solemnized on 7/2/2022 at Shikari Court. In view of the differences between the parties, the husband has filed MC number 26 of 2023 on the file of the family court, Bagal Court, seeking restitution of conjugal rights. Wife had filed a complaint under section 498A before the police station at Shikaripura. And wife has also filed a maintenance petition, that is criminal miscellaneous number 140 of 2023, before the civil judge and JM Circuit Court. What is this Honali? Where is it? Davangere. Now the present, it is submitted that as the wife is a resident of now residing in Unali, it's very difficult for her to travel all the way to Bagal Court. As such, the case MC may be transferred from Bagal Court to Davangere. The next one, Land Council appearing for the respondent husband has filed his objections, stating that the wife is not a resident of Unali, but she is a resident of Shikaripura, where she has given a complaint. Land Council submits that he is a government employee and it's very difficult for him to travel if the case is transferred to Davangere. He submits that he has filed a criminal petition before the principal bench, where the proceedings are stayed by the court. Land Council submits that the respondent, being a government employee, court has to consider his convenience also, and no reasons are made out for transfer of the present petition. Next para. Having heard the counsels on either side, there is a material on record. Then counsel appearing for the husband submits that he is working as a teacher. Earlier, he was working in Shikaripura. Now he is transferred to Ramdurga. The case is pending at the family court, Bagal court. On all the instead of, if now the matter is transferred from Bagal court to Davangere, instead of going to Bagal court, he'll be traveling to Davangere. Hence, it cannot be considered as inconvenience to the husband, considering the fact that already criminal miscellaneous number 140 of 2023 is pending on the file of civil judge and AMFC court. Finally, this court deems it appropriate to pass the following order. The MC number so and so pending on the file of the family court, Bagal court, Bagal court is withdrawn and transferred to the family court. What are this? The different prayers you sought? Something is wrong. At one place you call about Shikaripura family court. Somewhere you say to Davangere. Where it has to be transferred?
From that to down, only you are also Davangere.
Para 2, page 2. Some cut and paste work. Accordingly, the withdrawn and transferred to the family court, Davangere. Accordingly, petition is allowed.
Family court, Honnali comes under
Davangere.
Family court, she said family court. Look at your prayer.
It's only family court only Davangere. Family court falls under Davangere district also, that only.
Please look at your prayer. Court do not understand the names of the places and where are they. And look at your page 2. You call for Shikaripura. See, at least now make the change. What is that?
Yes, only you are also that is Davangere.
To the family court, Hunali, Davangere. Give it to her, let her make the changes. Yes, next, accordingly allowed. Yes, next.
Petition is the right my lord. The respondent husband has filed divorce petition.
What is this compromise copy?
Compromise.
It's entered.
Yeah. Yes, office, they are settled in this office. The respondent is ready to give the utensils and all the materials. She is also ready. And the compensation amount of rupees 2 lakh rupees and return the other amount. And the issue directing both the parties, advocates, said before the trial. There is no immediate transfer necessary for transfer.
No, that you can do. You can withdraw this and file a petition before the court.
Regarding the place of consent divorce, there is no agreement between the parties admitted. According to my instructions, moreover, the wife has requested that it be transferred to the Jamkhandi court, where they both will file an application. It is now filed at Belgavi. Seeking transfer from Belgavi.
No, wherever it is, for one time you can go and appear and get the
matter. Both are in police service.
Both are
in police service. That's why they are constables.
No. As far as that compromise is concerned, on that particular day you can go and compromise. For why it should be transferred?
I'll seek if it is passport is agreement for that.
Tomorrow, Mrs. Martin, tomorrow. Yes, next.
Interim order.
Interim order, all the granted is extended. At the request of counsel for the petitioner, Mrs. Martin tomorrow. Yes, 55. No representation for dismissal tomorrow. Yes, next.
Bill number 56 was denied.
Wife's petition, my lords. Wife's petition was dismissed, my lords, on the grounds that she has withdrawn herself from the
Notice. Yes, next.
Bill number 57, Shan Patapati, M.A. Makama.
Yesterday's matter, my lords. The children are residing with the respondent father, my lords. From Dharwad to Belgaum, my lords.
No representation by the petitioner for dismissal tomorrow. Yes.
Bill number 58, Arvind Kulkarni. Sheikh Kulkarni. Now bill number
connected CRP observed the objections to the other side.
Yes.
Finally said before this court. The appeal order is one and the same, which is challenged, both in the petition as well as in the CRP.
Is it clear? What officer? Oh. So, writ petition arises out of what order?
Out of order passed in the execution petition. In an application filed by the petitioner under order 21 to 97, claiming independent right, title and interest to the RPFC. Now, the execution court, the execution petition itself was filed for the execution of the judgment and decree passed by partition suit.
Yeah, I understood. You
I am
filed
not
a
party to the suit. I am neither a party to the OS nor in the
yes,
RPFC.
you filed a claim petition.
I have filed an application claiming independent right, title and interest.
What has happened to them?
Now, what the execution court, although orders for an inquiry, the scope of inquiry stands. And there is a subsequent event which has taken place. Now, I filed a review petition because there was one tara which the degree holders were trying to rely upon in the judgment passed with the RSM. I filed a review petition before the Honorable Division Bench, which passed the judgment in the RFM. My review application has been considered and an order has been passed, noting that I have already approached the executive court. The division bench has ordered that there be full adjudication with regard to right, title and interest. I will place that review application as well as the order that has been passed by the division bench.
So, when in a petition filed under order 21 rule 97, when an order is passed, against that a petition lies.
No, because insofar as the mentionability of the writ petition is concerned, there is no adjudication of rights. I can point out the decision which says if there is no adjudication of rights, writ petition is maintainable. They have not raised that as an issue also. Now, Your Lordship kindly takes the appeal order which is passed. I will give you Lordship to my application which I have filed in order 21 to 97 also.
No, we'll go to the order itself.
First, Lordship may kindly take the order which is at page 26. 5th of March 2024. Annexed is the order at page 23. Lordship may kindly permit me to read from 26 onwards. Mary Miller. Advocate to the third party argued the evidence is required, detailed inquiry is required on I number 2. Advocate for degree holders opposed said submission. Perused the materials on record. The present third party is stated to have come in.
So, in a way, your application is allowed.
My application is allowed.
And court had interfered with that, saying that no, it requires an inquiry.
Because their objections also deny any factual averments that I made in my application. I will read out now. I am only agreeing.
I am looking at page 28. Please read. 28.
28. I will read 28. This court, while passing the order on I number 1, 3 and 4, under order 21 to 97 of CPC, has held that no evidence is required. But the said sublessees are claiming rights through defendants 12 and 13 of the suits. That is LRs of Siddhingappa who are parties to the suit. But the present third party is claiming the right from original purchaser of the leasehold rights, Siddhingappa. So considering the nature of these in favor of the third party, and terms and conditions of the lease, I hold that detailed inquiry is required. The valuation of building has to be done, and whether lessee shall remove the building or shall recover the valuation of the building from lessor requires to be considered. For that, evidence is required. Order on application, so and so is treated as written. So I hold detailed inquiry is to be considered on I number 2. But I was agreed because of the limited scope of inquiry that the executing court.
Court never said so.
So that was our understanding, but subsequently, I will be permitted to place the review petition which I have filed.
No, again, can you read from the valuation of the building?
I'll read, but if I can just briefly explain. Now, their contention is that I am the sublessee of Siddhingappa Bulla. Now, my application that I have filed, which you have filed at annexed email, I have in a detailed affidavit. I have claimed as to how I have an independent right to the schedule income. I am claiming that Section 27 operates. The suit was filed by them, which fact was suppressed in the suit for partition. Detailed averments have been made in my affidavit that I have filed. Now, the executing court does not deem fit to hold trial insofar as my rights are concerned. Lordship kindly now sees, I will read from the motion, but the present third party is claiming right from the original purchaser of the leasehold rights, Siddhingappa Bulla. So, considering the nature of lease in favor of third party and terms and conditions of the lease, I hold that detailed inquiry is required. So, therefore, the executing court has not taken into consideration my other averments which I have claimed, which I have treated in my application, as to how I have got independent right title in interest. So, therefore,
court has never said.
My only grievance is my understanding of the order was a limited.
No, we have to understand from the plain language employed in the order. What the court said, you have made out a case by your application at Order 21 Rule 97. For that, evidence has to be adduced. And apart, court said, so all the things are required. Court didn't say, I will decide only one of these two issues. They are also required. That's what the court said.
Clarifies that issue. I have no grievance.
Yes.
I will go ahead and.
Yes. Yes, we'll hear it. No, as far as this order is concerned, the court is entertaining that application filed by him under Order 21 Rule 97. And it will be heard. He cannot have any grievance. No, let us understand what's your grievance. Yes.
As for the petitioners,
if I am permitted to just place the order passed in the review petition. It's filed in my statement of objection to the CRP.
Use the CRP. Next matter, CRP 58.1. Yes, where is that order?
Page 15, Worship may kindly come to page 15. This is my review petition, where again I have treated all the facts which I have treated in my application under Order 21 to 97. Now the page 42 is the order passed, which is subsequent to the filing of this petition also. Page 42. This is the order dated 5th of July 2024. I may be permitted to read page 47, very short order. Para 4 onwards. The perusal of the review petition shows that the review petitioners claim independent right over the property question. It is also brought to our notice that petitioners have filed an application under Order 21 to 97 of CPC in the execution proceedings initiated by the decree holder. It is to be noted that if at all the review petitioners claim independent right over the property, the review of judgment cannot be granted. More than that, if they have filed application under Order 21 Rule 97 of CPC, the executing court will decide right title and interest of the review petitioners or the property. Therefore, this review petition is not worth attention, hence it is dismissed. Now, by virtue of the subsequent order that has been passed to her, as your lordship also noticed, my grievance is resolved because this order will now have to be given effect and my right has to be achieved. That's all that I am seeking.
Yes.
No, sir. And for the petitioners in GRP, kindly come to page number 375. There is a flow chart. Here. Page number 375 CRP.
You are referring to the order in writ petition?
No, no, it is civil legal petition. Annexure L.
But it's no 375.
Yes, ma'am. It is.
10041 I'm looking at. Where is the other one? 58.2. Yes.
375 minutes. It shows in a nutshell as to how the parties have acquired the rights.
$70?
375 minutes. Flow of character.
What is the original suit for?
The original suit was for, it was a comprehensive suit for partition and separate function.
You are the plaintiff in the suit?
Yes, no. I'm the plaintiff.
What happened to the suit?
The suit came to be declared in my favor. And in that, the lessees are also.
The court has held that you are entitled for what share?
But I am entitled for 1/5 share.
1/5 share. Again, is that RFA is filed by the defendants?
Yes, ma'am.
What did the RFA court do?
The RFA filed by the lessee came to be dismissed.
Lessees have filed the RFA?
Yes, ma'am. It came to be dismissed. And the confirmed judgment of trial court. Kindly see, para 28 in RFA.
Para?
Para 28. Yes, sir.
Two? Where is the...
It starts from...
No, for the understanding of the court, where is the cause title in that, in the original suit, the judgment is filed? Where is that? Your suit is here at 180. So we look at the cause title. Please tell the court what are these, who are these parties?
Not the
Plaintiff, you are
1 and 2 are the sisters.
Yes. Then
Different number 1 is their brother. And different number 5 and 6 are other sisters.
Defendant 5 and 6 are sisters.
Sisters.
What about 2, 3, 4?
2, 3, 4 are the
children of D1.
Yes.
No, what about the 7, 8, 9, 10, 11, 12? There's a family member still. Where the family members are? Then? Then who are these 7, 8, 9, 10, 11?
They are the purchasers of a portion of the property from the different number 1.
Who are the purchasers? All are.
7, 8, 9, 10.
7, 8, 11 are the purchasers.
Purchasers.
So also 14 to 16. 14 to
16. 17. 17.
14 to something.
Or the purchasers.
Purchasers.
Then what about 12?
12, my lord, 12 and 13, they are, number 12 is, he is adopted son of one Siddhalingappa Bola. And 13 is widow of Siddhalingappa Bola. She is no more.
13 is widow of that Siddhalingappa.
That Siddhalingappa Bola is the purchaser of leasehold rights. He is the purchaser of leasehold rights. And the present respondent number 1, my lord, in this 1 and 2, they are claiming under Siddhalingappa Bola.
No, it is like this. The joint family property, D1 had sold in respect of some of the people.
Yes.
And this adopted son of this Siddhalingappa, adopted son Siddhalingappa is the original leaseholder. From whom?
From, he is the purchaser of leasehold rights. Original lessee is one Indian Cotton Company. In the year 1894.
Leasehold rights are for how many years?
It was
10 years.
10.
46. For how many years?
No, that was an issue in the suit. That was an issue. Whether they claimed that it is a permanent lease, and I said that the lease.
No, when the original lessee himself was granted 10 years to his, how will the subsequent purchase lessee or by way of any liquidation, why will he get a potential right?
Interpreting the terms of the lease.
No, even that liquidation proceedings are before this court? Which page is that?
No.
No, I'm saying, is it before this court? Page number. No, that's what I'm trying to say. What I'm asking is there a document or there in the record? There.
He executed the original suit. He executed the original suit. Where number 12 and 13 took up a specific plea of permanent tenancy. That was in the original suit. It was confirmed by the division bench of this court. Matter was taken up to the Supreme Court notice. All the while the matter has to be confirmed. This specific plea of permanent tenancy came to be rejected. Under the original lesser,
No, he was never part of the proceedings. He was, that was decided. His right was decided. That is, his right was decided before the liquidation proceedings or after the liquidation proceedings? And you are aware of the liquidation proceedings? And the order passed by the Bombay High Court where the rights were granted to him. Now it is like this. Now, whatever it is, he is not a party. And by the time an order is passed by the court, his rights are crystallized. How it is crystallized has to be decided by the trial court. Now, after the expiry of that particular lease, according to you, is 10 years. A competent court somewhere has decided that he is a lessee, or some rights are given by him by way of a procedure known to law. Now the executing court under Order 21 Rule 97 will decide whether it is right or wrong, or what is his right. I can understand, like there are no liquidation proceedings and the original lessee rights are decided by the competent court, which will follow in this case also. But here the twist is has decided, but unfortunately, in between, even before the original lessee's rights are decided, then his case is decided by the Bombay court. Original lessee, which is like which has been sold. Original lessee, no by what? No, he has some order from the liquidation proceedings. Correct. Now you say that that has been in the liquidation proceedings. He has been granted that.
No, that's wrong. That's what I am submitting about. In that liquidation proceedings, the legal rights which were held by Indian Cotton Company were sold by the official liquidator in favor of Siblingappa Bola. Thereby, by virtue of that sale, Siblingappa Bola
it is sold in favor of Siddharingappa Bola.
Yes, and thereafter, according to him, Siddhalingappa Bola has created a sublease in his favor by virtue of a registered document. And that's a right.
6th of April?
1964, registered lease. Kindly takes the dates and events in my petition. But I can just briefly take you also.
And the court holds that whoever is the original lessor, that's not a permanent list.
It is not a permanent list. That's what I am pointing out in this RFL judgment.
Page number?
Page number, it starts from page number 253. 253, 253. Because in this, the appellants were heirs of Siblingappa Bola. 253.
Relevant portion.
Relevant portion, para 28.
Para?
28, page number 2, running page number 291, para 28. Your Lordship got it? Para 28. As we have heard that lease was not permanent, neither the appellants or any person deriving interest under the defendant's 12 and 13 can claim immunity from eviction from leased property. They must deliver a portion to the plaintiffs and the defendants 1, 5 and 6 friends. So, my lords, this was the observation. As it is in this two appeals are for one appeal was against the FDP, one appeal was against the field multiple. And this judgment was challenged by the original lessee, the LRs of original lessee, before the apex court, which came to be dismissed. They also filed a review petition, they are also dismissed. Now, my lords, in this review petition, whatever just now my learned brother has referred to, in that review petition, my lords, they sought for deleting this para 28. Their ground was they are not parties to this suit, so it affects prejudicially to them their rights. So they wanted this to be reviewed.
No, under Order 21, Rule 97, a person who is in possession of the property and who has any claim in the suit scheduled property can file a petition.
No, not in any case. He should establish that he has got independent right manner. If he is claiming under judgment debtor, then it cannot be said that he has independent right.
I am not claiming to be there.
No, wait, please allow me to.
So you are claiming because you're saying whatever the registered deed which is there in your favor, 1964, that's from the original lessor. When the original lessor himself has no permanent tenancy, then that how can he give it to you?
Now the finding in para 28, These with regard to any person's
No,
claiming.
this all would be, this all, 1 minute. No, unnecessarily filing the petitions and keeping this pending. The court can adjudicate basing on the order passed in the RFA, which has attained finality by the virtue of the orders of the Supreme Court. No, there can be a finding that he has nothing to do with it. Why should you hurry to this court? The court can give a finding saying that no, if you give the court an opportunity, court will decide it. Court has not in their hand.
This application cannot be written by a third person. If a possession is taken, a third person may come on record and record of unauthorized possession. He is not giving an independent right. In fact, along with this person, another person was fighting over the property and made a particular application, whose application was dismissed. And he had approached this other.
Now the position is taken.
The possession is not taken.
He is in possession of the property.
He is in possession. He wanted to take possession, he had made an application. He comes with this application and he resists the obstruction. Takes obstruction. Now in proceedings, reading of 2197 was to show it is only a free word who can apply the 2197. That is how it is. The request to accept the release of 2197.
Right.
This is the obstructions to possession of immovable property. Where the holder of property or possession of immovable property or the purchase of any property or in execution of a decree is resisted or obstructed by any person in obtaining possession of the property, he may make an application to the court obtaining of the resistance of obstruction. So it is only I as a decree holder can say that.
A claim petition cannot be filed by a party who has been position. The provision might change, but there is a provision for that. No, for example, he is in possession of the property. He is not aware of any of the proceedings. No, you went to his place and trying to evict him. Then what he should do?
That is why, but such circumstances, if you want to take possession of the property, then 99 comes. In between 98 doesn't speak about that. A person who gets independent taken, whose possession is already taken, can apply for 99. Before taking possession, 97 is not an invention. Provision is as clear as this. It is only a decree holder who may apply. It is not absolute that I should apply for possession. Resistant. With the holder of the decree or possession of immovable property or the purchase of any property or the execution of the decree. That is a person who purchases the option.
If he doesn't allow you to take possession, what you will do?
I have to make apply to the court. If you have possession already, that is possession. Thereafter, 2199 comes. Make of this case.
So if we dismiss this, your allow your petition and saying that it's a premature stage for an application of 2197, then what will follow then?
First stage, prima facie is to establish that there is independent.
No, even according to you, or 2197 petition cannot be entertained, whether he is claiming under the decree holder or independent right. No, but no, this is the first argument. It should be the first argument.
So for a time, I say this is the first argument of the argument. In addition to this, because I have said my application was by. If my application is allowed, entire business will come to an end. On the ground that somebody's application is not available, if he has not been developed, I have this case, or he is not living independently. He also claims something. This is the problem. This is the problem where
Now let us see 99.
Covered by decision. Is there? Covered by decision to say that I need not be disposed to file that.
Read 99.
Who is dispossessed?
Where any person other than the judgment debtor is dispossessed of immovable property by the owner of a decree for possession of such property, or where such property has been sold in execution of a decree by purchaser thereof, he may make an application to the court obtaining of such dispossession. The intent of the obvious reason why this dispossession was, he should not be given to a separate proceeding.
Should be decided in the same proceeding.
We cannot object for taking the possession under 21 days. If I take possession, if he establishes the independent right, then his remedy is only after dispossession under 21 days.
No, he is not a judgment debtor.
He is very unjudgment.
But when was it? By the time your claim proceedings are pending, your suit is pending. By the time in the year 1964 itself, which year is this? 1964. No, here, this, when is your leader?
This is of the year 64. I have constructed the building after.
The person who raised the objection that he got he has to practice the suit. He is a submission.
He has been granted in 1964.
Why?
It's a registered document.
Yes.
It's a registered document for interpret. It's not actually.
No, because that person has already granted had given the property on lease to him, and he has taken substantial amount. He will not even any interest to pursue the matter.
It's not done as a point. Yet he paid a fee. The two of these were going on
No, when if it's a registered document, you will be knowing it. Why you have not made him a party?
Not, I am supported by the decisions of apex court in that, I will refer to that.
Yes.
As per, he has filed I number 2 memos. I number 2, third party obstructor's application. The law is, it has to be heard as a suit.
Yes.
And while maintaining that application, first the executing court has heard the matter regarding the maintainability. There is a decision of apex court, on the face of it, if the application appears to be not maintainable, the executing court, without holding any inquiry, shall have to dismiss it. That is the law. So when his pleadings go to show that he is claiming under the judgment letter. He is claiming, his claim is under the judgment letter, which is, of course, it is not an independent right. That's why that pair number 20.
Then his grievance should be answered by which court?
What?
His grievance or his.
He cannot have any grievance as against the decree obtained by me. That's
So then what is the remedy available?
No, so he has no other remedy. No, so he is settled, he has got any rights, he should go against his lessor, original lessor. Not any scheme. That's the law. No, in this regard, I have produced the.
Where are they?
There are decisions, my lord. Allah, you please don't divert. Or
will come.
Let him finish off, then I will let. No, if you divert,
yes.
The point to which the honorable court is looking at, para 12, first issue.
It's all complicated, these many bundles, where the papers are code is not able to understand. Where are the judgments? Are they filed along with the memo? Yeah, it is there.
Filed on 8/11.
you're relying on which judgment in WP number 100722? No. Order that is relied on is some WP order. Some order is there here.
Filed on 8/11.
Take that. Yes.
In this one, first edition, starts from page number 4. Relevant para is para number 12.
Para number 12.
Running page 7. Lordship Court.
Yes.
Taking the last action first, that is Raghuvansh's omission to include the appellant, it is quite clear that the law does not require that a sublessee will be made a party. It has been rightly pointed out by the High Court that in all cases where the landlord institutes a suit against the lessee for possession of the land on the basis of a valid notice to quit served on the lessee and does not implicate the sublessee as a party to the suit, the object of the landlord is to eject the sublessee from the land in execution of the decree, and such an object is quite legitimate. The decree in such a suit would bind the sublessee. This may act harshly on the sublessee, but this is the position well understood by him when he took the sublease. The law allows this, and so the omission cannot be said to be improper.
Yes. Next judge.
So, my lord, he cannot have any grievance against me for having obtained the decree in my favor.
Next, AR 1998 Supreme Court.
Yes, ma'am.
Which page? Which paragraph?
Not in this. Page number, para 12 and 13, on page number 12.
Para 12 and 13. Yes.
In this,
Yes.
it is, I am reading para 12.
Yes.
It is clear that executing court can decide whether the registrar or obstructor is a person bound by the decree, and he refuses to vacate the property. That person also query falls within the adjudicatory process contemplated in Order 21/1972 of the court. The adjudication mentioned herein need not necessarily involve a detailed inquiry or collection of evidence.
Yes.
Court can make the adjudication on admitted facts or even on the averments made by the registrar. Of course, the court can direct the parties to adduce evidence for such determination if the court deems it necessary.
Yes.
Then, in one word also and so, the reading of Order 21/97 CPC clearly envisages that any person, even including the judgment debtor, irrespective whether he claims derivative title from the judgment debtor or set up his own right title or interest, devotes the judgment debtor and he resists the execution of the decree, then the court, in addition to the power under Rule 35(3), has been empowered to conduct.
You are relying on 14 also. You are relying on para 14 also.
Yes, ma'am.
In this judgment.
Yes,
You
yes,
said
yes.
para 12 and 13, 14 also you are relying.
14.
Yes.
Then the next edition.
Next is, yes.
Starts from page number 15.
Yes. Para?
This brilliant para 9 method. Running page number 29.
Yes.
It is a right law that a third party applicant to maintain an application under Order 97/21 of CPC should possess an independent title, and applicant's title should be superior to that of the decree holder. In the present case on hand, the third party applicants are tracing the titles based on the unregistered service through the judgment debtors who have suffered preliminary decree passed in OS number 265/85 and also final decree passed in FDC 28/02. This court, in a section of the judgment, has held that third party can protest his position only in the event he is able to establish that he has an independent title. The third party objector who traces his title right
who the judgment debtor has no locus to intervene in the pending execution case. His right to protect possession is by showing legitimate, legal and better right and position than the decree holders. The finding recorded by the appellate court while entertaining the appeal that the third party applicants have a better title than that of the decree holder suffered from serious corrosive.
Yes, I have seen para number 10 in the till para number page number 32. Yes. Next.
Next decision.
Yes.
124. Para 12.
I've seen that also. Para 12 there is nothing. It's a penultimate paragraph. You are referring to para 34.
Para 18.
Para 18.
On page number 58.
Yes. Yes.
No. The executing, para 18 madam. The executing court has heard that appellants have failed to establish their independent rights in the mall and therefore not entitled to any inquiry under Order 21/101 CPC. In view of Withdrawal and the subsequent decisions referred to above, sub-leases, that is Withdrawal leases, the first decision which I have referred to.
Yes.
Sub-leases need not be made as parties.
Yes.
By the arbitral award, the SC has been directed to hand over portion of the properties. Messrs. IDEB is facing liquidation proceedings. Appellants have entered into sub-leases up to execution of certain lease deals between owners and Messrs. IDEB, and the same has been recorded in the sub-lease also. Thus, the finding recorded by the executing court that the appellants have failed to establish their independent right and therefore not entitled for an inquiry of 21/101. Then, my lords, this decision was confirmed by the apex court. Next document is page number 60. It shows this decision is confirmed by the apex.
Yes.
Then next last decision is, my lords, this is in respect of the property in question in this case.
Yes.
By another sublessee. Another sublessee in other portion of the property. He claimed that he has entered into a registered agreement with the sibling of Pabola, and thereafter his son Hole Pabola. Note in that he also stated that he has spent rupees 4 crores and has constructed a building thereupon, and his rights are to be adjudicated. So, my lord, in that context,
para 20.
Yes. Para 20 and 25.
Yes, yes.
Yes, ma'am. Para 20 is his claim. Similar, my learned brother was appearing on behalf of the third party aspect of therein. So, in this, para 30 madam.
Para?
30.
Yes.
The judgment of the apex court relied upon by the respondent. Page 87.
Yes. Yes.
30 minutes. In the judgment of the apex court relied upon by the respondents, it is very clear that the decree against lessee would bind sublessee. And claim of the petitioner is that he is sublessee, and apex court held in the above referred judgment that impleading of sublessee is not necessary. In the case of Silver Line Supra, it is held that the executing court can decide whether the registrar or obstructor is a person bound by the decree and he refused to vacate the property. That question also squarely falls within the adjudicatory process contemplated under Order 21 Rule 97(2) of the Code. The adjudication mentioned therein need not necessarily involve a detailed inquiry or collection of evidence. The court can make the adjudication on admitted facts or even on the averments made by the registrar. Of course, the court can direct the parties to adduce evidence for such determination if the court deems it necessary. Having considered the principles laid down in the judgment and also the facts of the case on hand, it is very clear that the right is para 32 minutes. In the case on hand, having produced the factual aspects of the case also, no doubt earlier there was a lease in the year 1894 in favor of Indian Cotton Company Limited, Bombay, and also
and held that lease would be renewed as a tenant holding on only if lessor accepts the payment of rent after expiry of the lease period. This court also held the act of holding over after the expiration of the term lease does not mean a tenant should recant. If a tenant remains in possession after determination of the lease, the common law rule is that is a tenant on sufferance. A distinction should be drawn between a tenant continuing in possession after determination of the term with the consent of landlord and